Ladies and gentlemen, thank you for joining us this afternoon. Appreciate you taking time out of your schedule to come down for our general election endorsement interviews. All the way to my left is Robert Kurth. He is running for Family Court Department D as in dog. All the way to my right is, do you go by Bob or Robert? Bob Teuton, who's currently the judge in Department D, who is running for re-election as well. In the middle, we have Denise Gentile. Is that how you pronounce it?
Gentile, actually.
Gentile? Mm-hmm. Denise Gentile, who is running for Department F as in Frank. Again, another family court seat. As I said earlier, these are all family court interviews for the rest of the afternoon. Yesterday, Denise, we had interviewed Bill Gonzalez. He had a scheduling conflict. He came in at some point in time yesterday. It was during daytime. I couldn't tell you anything more than that. So, that having been said, hopefully you're all provided with the letter kind of introducing AAG and our process in general, so I can skip that. First question that we're generally asking everyone is this, and we'll start with Denise, because you are the only female on the panel right now.
Okay.
So that's one of the perks. Why have you decided to run for this particular race at this particular time?
This particular race being this department?
Correct.
I chose to run for family court, number one, because I've been practicing for 23 years now, as of, this coming September will be 23 years, and felt that it was time to sort of put my money where my mouth is, and there have been some complaints about the depth and breadth of the experience on the family court, and so I decided to utilize my knowledge and experience and file for family court and hope that I get the job so that I can benefit the community with that background. So I chose this department because I'm not trying to badmouth this department, but his background is not in family court or in family law. It was in juvenile public defense work, which is criminal work. And so I thought that I could possibly benefit the community more so with my background. And that's why I chose this race and in this department.
Okay. And Bob, why are you running for re-election at this point in time?
Basically, my background, I started in 1977 as a prosecutor and spent most of my career working in the juvenile division or the family support division, actually supervising both those divisions as assistant DA before I became judge. As a result, I have an extensive background in child abuse and neglect. And for the last 2 years, that has been my assignment. Of the 20 family court judges, there are 3 assigned to handle abuse and neglect cases: Judge Sullivan, Giuliani, and myself. And I think my background is well suited to that. I intend to continue on that bench. It's a volunteer position, and I was the second person to volunteer. Judge Sullivan was the first. The third judge was appointed. Although she'd expressed some interest, it wasn't chosen. And it's not an area that most of the family court judges want to practice. So I'm going to continue my practice for the next 6 years counting that case.
And just to make it clear for Mr. Kurth, for Robert, Bob, I don't think I've ever appeared in front of you, quite candidly. I don't recall ever appearing in front of you. I don't get down to Pecos and Bonanza that often, knock on wood. I have no pending cases in front of you to the best of my knowledge, at least. If by some miracle that changes in the next 3 weeks before we issue our endorsements, obviously I will not participate in any deliberations, as that would be inappropriate, but at this point in time, I don't foresee that being a problem. So please, Robert, why have you decided to run for this particular race at this particular time?
You know, I grew up in the community here, so I've been here since I was about 3 years old. I grew up in the construction industry, and I've been practicing family law for the 22 years I've been practicing law here. When I was in law school, I was interested in it. I was a student editor on Family Law Quarterly at the University of Denver. And you know what I found is that we need judges in the family court who have that experience, who've been there representing the people, who have been in the trenches, who have listened to their concerns, who have felt what they felt, and understand how detrimental it is and how tearing the kids apart and putting them together and keeping the families and their income levels and evaluating businesses and how all this affects them, and how even other aspects of the law, such as if they have a criminal case or they have a bankruptcy or something else, all comes into play. And I have that experience, and I think that's the kind of experience we need in our family courts to make our judicial system the best it can be.
Robert, there's been some tension as of late regarding some people claiming there's an appearance of impropriety when a litigant who has given X amount of dollars to a judge and then appears in front of them, and the havoc that can cause with the system in general. What ideas do you have, if elected, to try and minimize that appearance of impropriety for people who have either supported you financially or perhaps were former law partners or close personal friends, college roommates, things of that nature? How are you going to handle those kinds of situations?
Well, I think you have to disclose the potential conflict so that everyone knows up front. And I think probably the most part, if you disclose it, I think the judge and myself, I'd be more apt to, they might want to have another one on the case, I don't know, because I'm going to make sure I do my best, that I am not, swayed, that I'm being the most fair and impartial I can. So once it's disclosed, then they would have the opportunity to decide if they think it's a conflict or a problem. They could talk to their attorney, or if they don't have an attorney, which we see predominantly in family court, self-representation. But I think that I could handle that situation. I am trying to stay away from some of those donation situations actually, so I can avoid that and avoid having that issue later on.
Okay, Denise.
I agree with Mr. Kurth, and in my situation, in my case, my opponent has that issue where there was a big donation, and I know that the Supreme Court ultimately made the decision that it wasn't a problem. However, I think that at the end of the day, the last thing you want is someone questioning your ethics. So if it appears to be improper, I think your best bet is to step aside from that case. I mean, it can't happen that often. It's not like, everybody in your courtroom is donating, the maximum amount of money to your campaign, nor are the attorneys. So I think Mr. Kurth is right. You disclose if you've received a donation. If the parties make a representation that they think it's an issue, obviously you would deal with that. And I think the appropriate thing is to step aside and recuse yourself. But if there's something that, like I said, this large donation that came to light in that particular case where my opponent dealt with the issue, I think you just need to recuse yourself so that your ethics aren't questioned. Because that's the one thing we have that we rely upon to, that's the biggest thing we have as attorneys, is to make sure that we maintain our ethics, and it's like the cornerstone of our jobs. So I think that would be the appropriate thing to do.
Bob, how have you handled these situations if they've arisen since you've been on the bench?
I've had a couple situations because of the years of the DA's office that some police officers actually appeared in front of me, and those are officers that I had developed a professional relationship as a prosecutor. At the end of the day, you want to be able to make a decision that both parties feel is fair and just and wasn't influenced by outside factors. So what I have done in those situations is made the disclosure and left it up to the litigants to confer with their attorneys, to talk to anybody they wanted to, then make a decision if they wanted me to hear their case, if they wanted another judge to hear it. Because it's critical that they have faith in the impartiality of the outcome.
Go ahead.
I mean, based on campaign contribution, when do you say how much money they're donating before you could say conflict of interest? Or is it a donation amount? Is a donation no matter how much? Is it?
Well, I think the U.S. Supreme Court has indicated there is a threshold. It's a threshold that none of us will ever see because it's millions of dollars. I had a case out of, I think it was Pennsylvania. But, I mean, quite frankly, I am not going to accept a donation if I think there's a quid pro quo attached to it. If I think whoever's making, as a matter of fact, I've had an opportunity, at least one opportunity to have accepted monies, and I didn't even participate because I didn't want the quid pro quo issue coming up in the future. By and large, the people that donate to our campaigns are attorneys that practice in front of us, and I think they make the donations because they recognize our competence, or either as a judge or as a person who's seeking judicial office. I can't put a definitive figure on it. In my race, where you're talking about, I think 2 years ago, the average is about $58,000 was what it took to run. In the races downtown, you're talking $200,000 and $300,000 if they're racing. If it's a $300,000 race and you get a donation of $100,000, that's inappropriate. That's 1/3 of your campaign. But if it's a $50,000 race and you get 1,000 or 2,000, it's probably not made with the intent to influence your decisions and it would be acceptable.
Denise,
Can I just say whatever he said?
Threshold?
That was
Ditto?
fabulous. Good point, pardon?
okay. Ditto, would that be
Yeah,
the?
absolutely. I mean, I think every situation is different, and like he said, you know, you wouldn't want anyone to believe that you're taking a donation for a quid pro quo kind of a scenario, but he's right. I mean, you just have to gauge it from, you know, each fact-specific instance. And I agree with him. Ditto.
Robert.
I agree. I think it's ultimately still disclosure. You just have to disclose it. I mean, no matter what, I think it should be disclosed.
You just said there's unlimited $100,000. Isn't the other races, federal races, there's a limit on it? The funds you can get?
Well, I think that's just a hypothetical. With, he was throwing out 100,000
There's
arbitrary.
There's a
There's a
limit.
$10,000.
Because somebody can already achieve federal, state races, you know.
Yeah, I think the limit in Nevada is $10,000 if that's found in the
Yeah.
Constitution. You know, there's some issues whether or not they're.
Yeah, because you said 100,000, I said, you know, I know all of, I've been doing it for 20 years. There's no 100,000 limit.
Yeah.
Well, if an attorney donates you $5,000 and then each member of their firm or
That I know,
or other, or
that
each giving you
happen.
$5,000,
There are big law firms that do that, I know that.
you know, then you have.
I know all bunch of it.
And again, I think the $100,000 figure that Bob brought up was completely arbitrary,
Yeah, okay.
Yeah.
just to fit the example. I think it was Robert. You had brought this up, so I'll reward you with being able to answer first. You had brought up the existence of pro se litigants. What ideas do you have to try and assist pro ses, either from an educational standpoint or from improving the self-help center? What specific ideas do you have to make the process easier for them to navigate through what is, again, a very difficult and complex and emotionally disturbing process of divorce or custody battles?
I think there's a lot of good things that we have done, and as far as expanding it, one thing, you know, I think we should be able to, and I've seen some judges do it, make decisions at the case management conference. So without them actually having to acquire to file, let's find out what the situation is and at least make a temporary decision at the case management conference. So we set that right away to get them into court, because a lot of times they file their complaint and they just think they're going to get divorced. Or they file their answer and they legitimately think that. And so then you set a case management conference, have them come in and talk about, okay, what's the process? Are there kids? Okay. But immediately when you get the case, if you see there's kids, let's send them to mediation. But let's explain it. Let's send them a little bit more information. This is what mediation is. This is why you're going there. Because we just send them there. Now they find out there, but I think that we should send them something that says, this is why I'm giving this to you. Go here, do your best, come back. If you don't have a decision, we're going to talk about it. And then we'll go from there. But also, I think sometimes when you have, you know, it's not easy, depending upon your day and your calendar, but to be able to have time to talk to them a little bit at the hearing, like a case management conference, and then send them out. And if you had somebody, if we had some other type of mediation, we have some volunteer attorneys that do some mediation, you go out there and just talk to them if they don't have an attorney for a few minutes, because sometimes it's just one little small issue, and it could all get wrapped up right then and there and put in a package and then save everybody a lot of time, save the judicial resources, save them a lot of money and frustration, because they don't know how to communicate what they want. So I think you have somebody there and you can take those couple extra minutes, they can communicate what they want and really understand what the process is.
Okay, we'll go with Bob next. Pro-PERS, what can we do to help them through the process?
Well, actually, I'd go beyond just pro-PERS. I mean, I would like to look at a situation such as they have in California, where there are more court staff, hired attorneys working for the judges that operate independently and require everybody to meet with one of those individuals before they even file their paperwork or are allowed to file their petition for divorce. John, one of the things that scares me are these joint petitions for summary divorce. They can only happen when there's no children involved, and it's just property issues and the status of being married or being divorced. I have no idea if the litigants really understand what their rights are that they're giving up in that process. And I think typically in situations where there's domestic violence or there's unequal power between the parties, where someone says, well, yeah, you're right, we've been married 30 years, but the house is in your name, therefore it's your house. Well, that's not the law. It's community property. And whoever signs off on that is unknowingly giving that right up. So I think there's got to be better education at the front for all litigants, particularly the pro se, which is probably 65% of our caseload, so that at least you are assured that the parties understand what legal rights they have to begin with. I think in that process, you have an opportunity to divert into intelligent, correct decrees of divorce without going through the entire litigation process, crowding up a court calendar with things that can be resolved by just sitting down and having someone impartially, and not be a court employee doing this, and discussing with them and getting the facts out up front and saying, okay, at the end of the day, this is probably what it's going to look like. You have the right to go have another thing, you have the right to go to court, but this is where it stands right now. And I think if we did more of that, education up front, we could probably, this is my peers aren't like this, but I think we could reduce the number of judges that we have on the bench by clearing out the clutter, the things that can be easily resolved up front, and just reserve the judicial costs and courtroom costs for those that are actual litigious parties.
Denise.
My answer is going to be a little more vague and broad, that I don't know the machinations that go on behind the scenes with respect to dealing with the pro se litigants, because I'm not on the bench and don't work in the courthouse, but understanding what those pro se litigants are dealing with just from an experience perspective, and knowing what they need to do to get a case through the process, I think will be helpful if I were to take the bench, so that I can lend that experience to whatever process is being implemented within the system. Obviously, alternative dispute resolution, mediation helps everybody resolve their cases typically. And one of the things we have now is the Family Mediation Center does the custody issues, but it's my understanding they're trying to implement that same assistance regarding the actual financial issues and the other issues in cases. So oftentimes people go to the mediation center and they don't realize their case is only going to be dealing with the custody, right, and they wish they could have dealt with the entire case. So I think that probably would be of assistance as well. But from my perspective, I just think that what I know from being on the other side of the bench would be helpful when ultimately being able to weigh in on those processes. So.
Did anyone else want to jump in, or am I going to keep monopolizing?
Just mention it.
Okay. Well, we've got plenty of time. That's why I'm opening it up. Well, I'll keep going then. This one we'll start with Denise and go to Robert next. Every 2 years the RJ does its mythical poll, survey, whatever terminology we use, and which is either the most accurate thing on the planet or not worth the paper it's printed on, or somewhere in between. What ideas do you have to make the RJ poll, the Judging the Judges survey, a more accurate assessment of the performance of the judges that are on the bench, and to give, for lack of a better term, civilians a better idea as to who the members of the judiciary are and how they are doing their job?
Wow. I mean, that's making the assumption that it's not accurate. I don't know if it is or isn't, because it's.
And again, it's how. Well, I'm not saying it is or it isn't, but how do we make it more accurate? How do we make it more transparent? Or is it? Or an appropriate response is, I think it's perfect.
I'm not saying it's perfect, but maybe there would be more disclosure as to how many people voted in each of those particular races, because I think that it's all anonymous, and then it's not really disclosed. Did 10 attorneys vote for Judge Teuton, or did 500? I think that's not disclosed. And then maybe also ask the judges for some input as to their backgrounds, so that the public can read up on that as well when they're weighing what the poll says versus what the judge has to say about the poll itself. I mean, I think that they do that, don't they? Do they ask you afterward about
Yeah,
that?
they, in
Sorry.
some cases.
No, I'm turning to him.
Well,
I think
again,
they
you've
do.
never been in the position of, maybe we'll go to Bob next time.
Yeah, I've never been in that
Robert,
position,
yeah.
but I mean, in terms of, you know, the poll itself, I think it has to remain anonymous, otherwise people wouldn't actually weigh in. All the judges are fabulous because the attorneys aren't going to want to go out there and say that, you know, they're horrible. So I think you get more accurate representation because it's
Right.
anonymous, right? But at the same time, maybe it would be better to know how many are actually voting on each of the different judges, because I don't think we know that. So it might not really be a real accurate representation if it's only 10 attorneys voted for Judge Teuton versus 300 for this other judge. Do you know what I'm saying? So
Well,
that's all I can really weigh in on at this point.
I guess we'll go to Bob next and then Robert, if that works.
Well, I guess the first thing is I'll tell you the same thing I told the RJ during the editorial interview. That is, it's not the best, but it's better than nothing, because we in fact have nothing but that, really. What really needs to be done, and this election really illustrates it, there's going to be 54 candidates on the ballot in November. And there was close to 100 before the primary. And how is the public ever going to know? I think what we really need, if we want to be serious about the public making informed decisions about judges, is that we need to have independent observers. Again, you're talking about probably government, or perhaps you could get private enterprises to donate money to some nonprofit to do this, that actually sit in the courtroom and watch judges' behavior on the bench, because that's probably the key. There's always allegations that certain attorneys are stacking votes in favor of somebody, or the allegation that, well, yeah, I got a bad vote because I upset 2 or 3 attorneys and therefore they're mad at me and so they're going to take it on the poll. I don't ascribe all that ill will to that many people. I think it's kind of a valid general starting place. You know, I had 81% dishonest time, which was 4th highest in the district court bench retention rate. So I did well in terms of the poll, and I appreciate that. But what I also appreciate is an opportunity to review the comments to see where I'm weak and where I can improve. And I think in those states that have gone to pretty much eliminating the contested election process, most of them have a government-sponsored court watch scorecard where every judge is independently evaluated, and that information is made public to the voters during a retention election, where they're not running against anybody but their own election, their own record. So that would be a better step. Like I said at the beginning, it's better than nothing.
Okay. Robert.
It is difficult. I mean, both comments that were made, we don't know how many people voted. If we don't know, you know, you're supposed to vote if you've had experience with that judge, but that's up to you to say that, whether or not you're doing it. And it's true that, I'll tell you, if you practice in the justice court doing criminal evictions, a lot of them don't know the family court, or they definitely don't know the district court, or if they're just practicing the district court, they don't know the justices of the peace, or they might not know the family court judges. So it's hard to know how it's skewed. I think that would be a better way to, I mean, if we were going to do that, we should allow some public comments too, and kind of, you know, you're going to have good and bad. I'm sure everybody's going to have some good, and there's always somebody that's not going to be that happy, I'm sure. So there's going to be some bad. But if you skew it all and then put it together and kind of average it out, I think that would be better. That would at least be a start. Because I don't think everybody knows in the experience. And like, for instance, you know, Judge Teuton got a good score. I'm running against him. My position on that is I don't know who voted. I don't know how many people voted. I don't know what's going on there. I know that he's been doing abuse and neglect the last couple of years, not divorce, in custody, and other things. So, I mean, that's my position on that rating. So how much do we give it? I mean, how much credence or credibility? We definitely need to do something else. I think his idea of some independent observers, groups being involved is a good idea.
I agree.
And Bob seems to be in favor of, I guess, almost moving towards the Missouri plan in general for the appointment and then the retention. I don't want to put words in your mouth,
Right.
but is that fair characterization, Bob?
It's places like Missouri, and I think Colorado as well, where it's a retention, and they do have independent entities, judicial performance evaluators that go in and look. At the end of the day is what do you expect of a judge? Okay, and so you look at the factors, you look at their ability to make decisions, their preparedness for court, their timeliness of being in court, their work ethic, their demeanor on the bench, how they treat litigants. And you evaluate all those things because all those components are going to determine whether or not, as a litigant, you're willing to accept the decision that judge makes. That's what we need to do, and do it objectively and not based upon unknown attorneys with unknown agendas, or at least agendas that are subject to being attacked. So yeah, that's pretty much it.
Okay. Robert, how would you feel about moving more towards the much vaunted Missouri plan that has been bandied about for a couple years now?
I'm not opposed to that. I mean, I think there's politics in everything. So I think you get appointed, there's politics. Who knows what's going on, or why did this person get selected over that person? So, but I guess with the Missouri plan, you could come in and have a good, unbiased evaluation and determine whether or not it should stay that way or not. Because there's definitely judges we have that get really, really terrible ratings, and other people don't even run against them because of various reasons.
And I've been asked the same question before, and I have the same answer. There's politics and everything. But at the end of the day, like right now, it's all elected. So you rely upon the electorate to learn who they're voting for, but they don't. And even with a retention plan, you still have to rely upon them to do the right thing and learn who they're retaining or getting rid of. So there's still that sort of facet to the whole thing. And you just hope that people do their homework and learn who the candidates are.
Okay.